Okay, hi. Thank you everyone for being here. Paul and I are defense attorneys at Berry Law. I've been a defense attorney for 14 years. Paul has been with our firm for 3 years. Before this, he did civil work, so he has a lot of background on the civil criminal overlap. But the purpose of today's presentation is there's things that people can do well before they're ever even contacted by law enforcement that could ultimately impact the trajectory of their criminal case. And so we're here to just talk about if you ever have a client or family member or friend come to you in your civil or domestic or contractor, whatever settings that are non-criminal, just to give some basic advice, because decisions need to be made right out of the gate, maybe before you have time to contact a criminal attorney. So we're just going to talk about things that we see come up. I would say that most of our criminal cases, there is some sort of civil overlap, whether it's a custody proceeding or work or a Title IX proceeding at a college or university. So that's what we're going to talk about today. Please interrupt us. We want this to be collaborative and helpful to you guys. So if what we're talking about is not helpful, but you have some questions about something else, just feel free to interrupt us. So with that, okay, that's kind of what I just talked about. So this is the cardinal rule: don't talk. And it's not just don't talk to the police, it's don't talk to anybody. Anybody that somebody makes a statement to can be a witness against them, even their spouse. There's spousal privilege, but when it comes to certain types of cases, child abuse, sexual assault, even someone's own spouse can be a witness against them. There's no privilege in certain types of criminal cases. So the cardinal rule is don't talk, but don't talk to anybody other than an attorney about the allegations, even if you're denying them. Clients talk themselves into jail cells real quickly, not the other way around. What they say is almost certainly going to be twisted in a way that ends up getting used against them, whether it's something they say to law enforcement, family, friends, etc. So if you have somebody come to you and tell them nothing else, it's just don't talk to anyone until you talk to a criminal attorney. Why? We're gonna skip this video. Sorry. Okay. So here's some situations that come up in people's lives where they are inclined and feel like they need to make a statement, and how it can ultimately impact them, and when we would say, no, don't talk. So detective wants me to come down and just hear my side. I was at a party last weekend and this girl's accusing me of sex assault, and the detective said, hey, we just need to hear your side and clear that up. No, that's not what they're trying to do. They're trying to get a statement that in some way, shape, or form corroborates what somebody's accusing them of. Let's say somebody goes in and says, well, yeah, I had sex with her. It was consensual. She said she wanted to, and here's all the things she did ahead of time to show it was consensual. Great. What if she's telling law enforcement she was too drunk to consent? You literally just proved all the elements for them with your own statement. So people don't even know necessarily what they're being accused of in certain contexts. So you're giving a statement about something that you don't necessarily know about. Law enforcement is 100% allowed to lie to people. It's a tactic they're allowed to do. They're trained to elicit confessions, not statements, not truth. And this is not a knock to law enforcement. I mean, this is their jobs, but that's why it's just so important to not have anybody talk to the police. School, this comes up a lot. So student disciplinary proceedings, we have a ton of high schoolers, even middle schoolers who are accused of certain things, and schools have an obligation to immediately launch investigations. Schools that receive funding through Title IX, high schools, in terms of, they don't want liability of letting something go on in school. So they launch these investigations. And one of the very first things they do is ask the respondent or the accused, what's your side of the story? What happened? There's FERPA, there's certain privileges for schools. I will tell you that 100% of the time when I've had a case that involves a companion, like Title IX proceeding or student disciplinary action, either the prosecution or the defense has been successful in subpoenaing the entire case file. So even though it starts confidential, they're usually drawn out through the subpoena process. So again, I'm not saying never ever, and we have had certain situations. We do a lot of Title IX defense as well, where we have had people give statements, but if what they're being accused of could amount to criminal liability, domestic violence, sexual assault, things like that, we tread very lightly. Most of the time we're telling them not to make a statement. And again, it can, of course, impact them in the school setting, but we're always looking out for what could happen criminally. So a little bit more about Title IX. The burden in those cases, does anybody do any Title IX or student disciplinary stuff? Has anyone ever been an advisor? Okay. So the burden is really low. The complainant just has to prove their allegation by a preponderance of the evidence. And schools lose their funding if they're not compliant with Title IX. Title IX rules and regulations change all the time, usually depending on who's in office, which is kind of dumb in terms of the amount of due process that's allowed. But the burden is really low. And again, like I just talked about, if somebody is facing an allegation that could amount to criminal liability, you're not typically going to talk your way out of a Title IX responsibility either. Now, if you have objective evidence like text messages or other witnesses who saw things like that, we certainly want to gather that. So that's one of the things that I would say to these people is don't make any statements. Don't go talk to the Title IX coordinator or the principal or whoever may be like running the investigation, but anything that you have, like get it together, preserve it, screenshot things so that you can talk to, an attorney that you're going to use. But you never want anyone to go into these kinds of things just defending themselves. And it's human nature to want, especially when you're accused of something you didn't do, to want to explain yourself. And but it just doesn't typically go well. Sorry, do you want to chime in and all of that stuff?
Well, I think to build on that, if somebody gets a notice of allegation that there's a Title IX investigation being launched against them due to some sort of complaint, you better believe within days of that, whoever is leading that investigation is going to want to talk to that individual. And take a college student, for example. You're a sophomore at UNL, things are going great, you have all these aspirations, you're doing really well, everybody's proud of you, and all of a sudden you get something sent to you in an email saying, your ex-girlfriend has accused you of sexually assaulting her at some party. Hey, come down and let's talk about it. You're like, well, that's not true. And you're a smart individual. You go to, maybe you tell your parents or you tell some friends, you go down there and talk right away. Next thing you know, you did an 1.5 hour recorded interview with an investigator, not law enforcement. And at the time, like, okay, I told my side of the story, dust is going to settle. Far from it. One, that's just like the tip of the iceberg in terms of the Title IX investigation. It could go on for months, a year, and then ultimately culminate in a hearing. But along the way, if you just went and sat down to this recorded interview, maybe law enforcement reaches out to you, but at that point in time, you've already got an attorney who's telling you we're not going to go do an interview. But if law enforcement finds out you went and talked to the investigator for the university way back at the beginning, they're going to work to go get that. And that's a roundabout way where, fine, your criminal defense attorney is saying, we're not going to come down and do an interview, we're not going to talk, but they know there's like a treasure trove of information that the school's sitting on. I would say most of the time in Title IX cases, we hear from parents. And that makes sense because those clients are 18 to in their early 20s. Mom and dad are still involved in their life, or if it's a high school and it's a school district doing it. So the parents are usually the one making the phone call. And it's going to be those parents that might have pre-existing relationships with civil attorneys in other areas of their life. And, you all might be that first phone call they make because it doesn't really necessarily always look criminal on the surface. And maybe it's not. I have Title IX cases where it's like, this professor stared at me in what I believe was a sexual way. Okay, that guy's not getting charged with the crime, but Title IX will still like run that the full distance and we'll go to a hearing. That's different. But if there's anything like even remotely in the realm of that could maybe be a crime, when the parent reaches out to that one connection they had that's a civil attorney, I think then it's on you all to say, okay, let's just then hit pause. Your daughter, your son, nobody needs to go do anything. Let's get somebody on board where we can, sort this out. Because there's no timeline. Like these investigators will say, hey, we need to come talk about this right now. That's just an arbitrary timeline. It's an arbitrary date. As Mallory said, yes, the school, the institution has obligations to comply with Title IX. Our client doesn't. That's their problem. And so a lot of times we just had to put the brakes on it, kind of get our feet under us, figure out what's going on, and then determine does going and doing an interview make sense or no? An interview is not going to make sense because we could potentially be incriminating ourselves. And if that means that's the difference between potentially staying in school or not, because we have cases that we go all the way to a full-fledged hearing, the client never testifies or gives a statement because they can't. It'd be a bad idea. And then we have to let the chips fall where they may in terms of what the sanction is if we don't get the outcome we want. Maybe that sanction is they get expelled from school, or they're not allowed to be there for a semester or for a year. Or we get the case resolved through informal resolution, which is not going to a hearing. I mean, there's a number of ways Title IX cases can shake out, but the point is, at the beginning, if you ever hear from some client, it's the parent of the student, hey, they just got this notice, the last thing they should do is go run down there and talk to somebody about it, because the notice of allegation will be just that. It's a notice. I mean, it's not even as detailed as like a complaint that was filed in civil court. It's going to be super bare bones. Nobody's going to know anything about it, but they're going to want to go talk about all these things. So you don't even really know what's being alleged against you, but they'll gladly take a statement. So just put the brakes on that as best you can until you confer with somebody else. That's the point.
Yeah, we had a case. We represented a Creighton law student who was accused of sexual assault, and both through a Title IX proceeding and criminally. And we were maybe 10 days out from trial, and we did this last minute deposition of the lead case agent, and we got some discovery last minute through that she had been emailing with the Title IX coordinator at Creighton, trying to get as much information as she could about the whole situation. She actually made some statements in there that she probably shouldn't have, and I got the case dismissed like on the eve of trial, basically. So it was kind of helpful that she did that. But the point is law enforcement is doing that, and we only found out about it because we asked the right questions in a deposition last minute. But yeah, they're doing everything they can to try and get people's statements, because these are he said, she said cases. A lot of times there's not evidence, and it comes down to the credibility of the accuser. I had another case where I represented a Creighton medical student resident accused of sexually assaulting another former medical student in Vietnam, and Creighton exercised jurisdiction. She didn't go there anymore, and that case went on for 2 years. We were successful actually just a couple weeks ago, but we never let him make a single statement. All we did was utilize evidence like photos, text messages, other witness statements. You kind of go back, and if you don't get a hearing, this didn't happen on campus, so Title IX didn't apply. The student disciplinary code did. It's just kind of this back and forth of submitting argument and rebuttal and evidence, and there are ways to be successful without giving statements, and oftentimes statements can hurt people. But more and more, there is overlapping criminal implications. You don't have to even be a lawyer to be an advisor for somebody in a Title IX or student disciplinary action. But gosh, we recommend that people have not only an attorney, but an attorney who does criminal too and can recognize, oh, this could trigger some criminal implications. So yeah, this stuff's coming up more and more. I mean, our firm probably has, yeah.
Sorry, I don't want to break low, but
No.
it's fascinating stuff. But I'm curious, like, who foots the bill for you? Like, I could foresee a scenario where, your kid gets accused of this, and then you're like, oh, I was drunk too, I'll accuse her. I mean, it just has to get out of control. Like, are the parents paying your bills, or how was that work? Is there any fee shifting in the statute?
No, I will say we have done dozens and dozens of sex assault, Title IX trials, not just sex, and won, like not guilty verdicts, or like this medical resident, his dad helped him pay. I mean, lots and lots of money, and like they're not gonna recover or just die. I mean, it's yeah.
I mean, obviously it's good intentions, but it's
Yeah. I have never in 14 years had a single client recover civilly after getting a not guilty verdict, having a case dismissed, winning their Title IX case. I have never seen someone. It's not to say it doesn't happen, but there's a lot of litigation. Yeah,
There's no insurance lines that cover this.
I don't think so.
All right, $1 billion, yeah.
Yeah, there you go. Oh,
Your example that you just gave that Title IX didn't apply. So Corey, try to. Is there a great support?
So in that case, there was just a decision maker. So she just reviews this whole case file, and this one had to have been 150 pages of stuff back and forth, and she just makes a decision, like, did the complainant prove this by preponderance of the evidence? One person reading stuff.
arbitration.
What's that?
Almost like an arbitration.
I don't have much experience with arbitration, so I don't.
I wouldn't go that But yes and no.
Just don't really apply.
Oh, no.
No.
No, not at all.
Due process doesn't, no.
No. Yeah, like I have a hearing tomorrow with UNL. It's going to start at 9:00. My role is limited to just cross-examination of whatever witnesses want to be there. I don't have any subpoena power. I mean, there are witnesses that I believe are like favorable for my client who have indicated to the university just as recent as like late last week that, hey, actually I am available. And the hearing chair of a 3-person hearing board unilaterally has decided that, well, they already gave statements in the final investigative packet. We don't need to hear from. Well, okay, but the other individuals who are not as helpful to my client, they'll be there, of course, and that's fine. I'll get to cross-examine them, but why would you not also want to, allow these other individuals opportunities so we can elicit useful testimony? Everybody always calls it kangaroo court. It can feel that way. I mean, I can't give an opening statement. I can't make objections. I can't control who will or won't be there. I can't make the closing argument, but at least we can do the cross-examination. And most of the time, our role, yes, we're attorneys, but they call us advisors. And an advisor in the Title IX setting or the student disciplinary setting doesn't have to be an attorney. Like, if you just want an advisor or a support person, it could be anybody, really. It's pretty broad. Once you get into, though, like who's going to do a cross-examination, I mean, it goes downhill pretty quick in terms of how effective your support person really can be for you. But kind of back to your question, and to my statement earlier, when somebody gets a notice of allegation that a Title IX investigation's been opened up against them, they might then in the same week get a notice saying Title IX's been dismissed, but we're going to proceed under like the student conduct code. Because, for instance, it happened off campus, only one of the individuals is a student, the other individual is not a student, and it can get kind of like wonky about like how the university or college wants to use their jurisdiction. And it even goes beyond that, not just how they want to use their jurisdiction. Some colleges, smaller colleges, their rules are they won't even talk directly to your advisor or your attorney. So then we have to confer with the client, put together the email, then they have to send it. It can just get real complicated really quick or really nuanced. But I think the biggest takeaway is if you have clients that one way or another indicate to you that they have like a son or daughter or a family member, somebody that's in a college or university is facing either student disciplinary action under the student conduct code or Title IX, the sooner the better in terms of talking to somebody, because they can really make a mess of it really quick, whether it's giving statements or just get too far down the road and like make concessions about things they'll do and say because they think that's going to help. And it just can get really messy really quick. And then they're jeopardizing like a degree.
Yeah.
If potential is the person is expelled from school, and will this like you have some kind of public record of the expulsion and leaves?
Yeah, so, well, not public, but if somebody gets expelled, that'll be noted on their transcript. So when they go try and go to another school, the other school will inquire about that. Sometimes,
So these penalties can be pretty severe.
yes.
And if it's a state school, then wouldn't it be a violation of due process for them only to let the people who are adverse to your plan testify and not let people favorably testify?
Well, I mean, I think that's the argument on the back end of it. Certainly, and what we do a lot of times is when we get those decisions from them along the way, then we'll come back to them and make like that argument. And at that point in time, they'll generally say, okay, no, like noted.
Yeah, we usually do this like really intensive due process request, knowing that it's not like what we're asking for is not allowed under Title IX, but like we're putting it in there and why it's necessary so that we can preserve potential issues for appeal. There's a lot of civil attorney. There's some guys we work with in New York that have been really successful in suing colleges and universities across the country. I think University of Denver was the most recent one for lack of due process, various violations. So we kind of just like throw everything out there. This is where we're at. We ask for everything, knowing we're not going to get it, but the goal being
So
to
you're right there, so you don't waive it.
Right.
But you say on the back end, you made after the determination is made.
And let's say it's an adverse determination, and then they impose a sanction, something as severe as you can't go to this college anymore. Then we've preserved this stuff, we've gotten their responses, and then we can handle it to somebody that wants to take that fight.
Yeah, Title IX is complicated. It's changes all the time. I don't even know what the current. I haven't had a contested hearing in years. You probably know, but I don't even. I mean, are you cross-examining under the old regs or like the updated ones?
The old.
Yeah, because there's updated one. I don't even know if you can. Yeah, it's. Sometimes what we do too, like we have a case right now where our client's being investigated by law enforcement. We're almost certain he's going to get charged. He voluntarily withdrew from school, and that will usually trigger a dismissal. Now, some schools can continue to proceed and render a decision even in the absence of a student, but most times if somebody voluntarily withdraws, they'll just close it out. I believe that still notes on the transcript voluntary withdrawal pending conduct resolution. So there's still going to be some explaining to do if you transfer somewhere, but that's a lot of times when we know a criminal case is coming, it's like, we're not going to fight this. We're not going to go be putting evidence out there because we want to save what we have for the criminal case. So that's a lot of times we have to pick our battles.
Is there even a short list of procedural rules and how you proceed with these various hearings, or is it?
Well, the school, each of the colleges or universities has their own published procedure that they abide by. And, they interpret and they kind of, further delineate from the federal regulations and have their own spin and flavor on them.
Yeah.
But again, if it's Title IX, it might be one thing. But if it's under the Student Conduct Code, for instance, like at UNL, you don't always get, if it's under the Student Conduct Code, you don't always get an option or the ability to cross-examine. Sometimes you'll have to submit your questions in writing to the decision maker, and then they're going to ask those questions. So it's not even a cross-exam at that point. But even for the cross-exams themselves, when you have like your pre-hearing conference, they emphasize, you're gonna ask your question, pause, give me time to think about it, if it's an appropriate question, and then, I'll permit the witness to, you're like going into it with one hand behind your back. Which seems just inconceivable given what's at stake, which is somebody might get kicked out of school if this doesn't go a certain way. But that's the uphill battle.
Yeah. Yeah, this is more, we represent a lot of high schoolers, and so there's a lot of Snapchat and, like my friends are asking me what's going on, and people at school are saying, and it's like you can't go say anything. Like we don't even want you saying, I didn't do this. We say, I have a lawyer, my lawyer said I can't talk about it. That is it. So no one is safe to talk to.
Well, and what I would say about that, it's that, so in addition to, okay, you have this Title IX investigation, but also these individuals are at the stage of their life, they really care what their friends and their peer group think. And, this rumor spread like wildfire, and next thing you know, their reputation in their world is coming to an end because all these rumors are floating around. And maybe it's totally not true. They had this allegation made against them. There's Title IX, but rumors are spreading, and so they want to know what they can do about it. And we've consulted with civil attorneys before, like, is there a defamation angle? Because maybe people go on and they start making social media posts. Hey, the victim here is my best friend, and this is what I can't believe that Bob Smith would, he's a rapist, and whatever. And then, but this stuff does really impact their lives, and then they feel like they can't go to class, they can't be in a club. It can get complicated quick. And then the universities have these really stringent provisions about, you can't retaliate. So on one hand, it's like, well, wait a minute. If another student who's not supposed to be knowing about an ongoing Title IX proceeding because it's confidential is talking about it in some public setting, has that student violated something? Is there a complaint I can make against them? I haven't had much luck at that, but sometimes we try. Or if we try to bring some action against the individual who's spouting off in some public forum about stuff that's supposed to be confidential, are they going to say, now we're retaliating? It can get messy really, really quick. But again, that would probably be the one thing I'd say where I engage with a civil attorney at the soonest in a Title IX proceeding is about, is there like a defamation angle on this? Should we send some sort of cease and desist to take some posts down or to modify some posts? Because that's becoming more and more prevalent just with the age of social media.
Yeah, and something I learned from a civil attorney recently is that there's like a pretty quick turnaround from when they have to send notice of the defamation, because if they don't send it, then they have to prove malice or something like that. I don't know. I'm not a civil person, but there is a pretty quick timeline in terms of if you're going to pursue something like that, that you have to do out of the gate. Now, we always tell people to tread lightly, because if you actually file a formal suit, then you're going to be open to depositions. We're not going to let you give a statement if you're, but anyway, there is some timeline in that too. This is a big one that comes up. I mean, we have a lot of cases where our clients are in some sort of a pending custody matter or juvenile or whatever, and they want to go defend themselves or their position or work towards child custody. And usually we're saying, sorry, you can't go do that, because something that you say, the attorney might ask you something, and at this point you're under oath. That's about the worst kind of statement that you could make that could potentially be used against you. So again, it's not never, but I mean, most of the times, if there's criminal implications, we are saying, no, don't do it. This comes up a lot in terms of when there's, were you gonna say something? We can hit this slide if you want. Or I can.
Oh, well, I'll address the very first part of this. Everybody that calls in, it's a DUI, it's an assault, whatever, and rightfully so. Everybody says, "Oh, I don't want this to impact my job. I don't want to get fired. I don't want to be on some restriction." Like, first off, I can't control what your employer, your boss, or whatever they do. But a lot of times, it's like, well, let's think through this. This just happened. I get it. You're a stellar employee. You're an honest person. And the first thing you want to go do is just tell the world you got this thing going on. Okay, you could do that. And then they're going to have a lot of understandable questions. And you're not going to know the answers to any of them, because you've only just received a citation. You haven't even formally been charged. You haven't even talked to a defense attorney yet. And so they're asking a lot of questions that you don't have answers to, or you go and you Google stuff and you look things up and you're like, well, I saw that this is punishable by up to 1 year in jail. And they're like, well, are you going to go to jail? Well, I don't know. And it can just snowball really quick, and everybody's like assuming the worst is going to happen. It's usually better, like, let's dial it down a little bit. Now, for some jobs where you have like mandatory reporting requirements, if you have any adverse contact with law enforcement, or you get stopped or you get arrested, there are jobs out there where that's just a requirement. You're going to have to tell somebody, and those are different situations. But I think on average, before you go and you tell a bunch of other people that aren't going to be involved in the criminal proceeding at all anyways, have a consultation, get a defense attorney on board, and then we can figure out what's going to make the most sense for you. Especially, like, let's say you're a credential holder, you're a nurse, you're a doctor, you're a physician. Well, okay, but do we have to go say anything right away? I mean, certainly if you're convicted, we're going to have to report something to the DHHS or, the applicable licensing board within 30 days on the back end of that. And we'll deal with that fallout at a later date and time. But on the front end, do we have to? Like, I don't know. I mean, it's not a cookie cutter approach, but it always seems to generally make sense to just slow it down a little bit. Everybody's really eager to want to talk. And I get it. People think, I'm going to have court appearances. I'm going to be gone. I'm going to need to take time off. It's in another county. I got to travel. How am I going to manage this? This is like the worst thing ever in my life. And so they want to, kind of get in their boss's good graces, for instance, and make sure they build in that permission ahead of time, and everybody, that support, so they feel a little bit better about the situation. But all things considered, that's not really the best course of action. It's just, let's slow down. Let's talk to somebody so you can exactly know what you're up against. We can help you figure out if that conversation is going to happen, what it needs to be like. Or a lot of times, I might end up talking to the employer or the boss or whatever, just to say, okay, what are your questions? What can I answer? Procedurally, we're just at a high level. We're not going to talk about the facts of the case, but something to educate you so you understand a little bit, so your mind's not running wild that, this great employee you have is days away from going to jail, and now you're like, how am I going to cover down on that loss?
And we've had bosses get subpoenaed to testify because our clients made statements to them, coaches. I mean, again, it's all, every statement can come in and be used against them. The second part of this is in there. I had a case where there was an accounting discrepancy, and boss and my client had a conversation, and client wrote a check for what client thought was the correct discrepancy. Boss thought it was way under, and that check was like exhibit number 1 in the criminal case. So again, it's just, and boss was a witness / the victim in that case, but yeah. So
I was just wondering if you could speak to where there's been discussions about how universities have an insular view of things that occur on campus. We'll take care of it internally. We don't need to contact the police to see if we can work it out. And the evolution of that, where cases blow up historically, and then hopefully university learn from that. But do you still see any sense of the insular, we'll just take care of our own internally, we don't need to be reaching out to police? Does that come up at any time in your?
I don't think we often see universities contacting police. I mean, usually it's like the victim, or I mean, a lot of times it's the victim needing to go to police, because at the end of the day, law enforcement, prosecutors can't really move forward in a victim case anyway without the victim being there to say what happened. So I don't think, I think universities are kind of just staying in their lane in terms of, this is our obligation under Title IX so that we can keep getting our funding, so that we're not exposing ourselves to civil liability. We're going to do what we need to do. If they want to go report it to law enforcement, that's their prerogative. We're just doing what we're required to do. We see them operate. I think universities don't like getting wrapped up with law enforcement. They don't like when law enforcement wants to talk to them. Like, they want to just do their thing and let everything out, They get looked into. I mean, I had a Title IX coordinator get subpoenaed by a prosecutor in a trial a few years back, and then had to divulge everything. And like, I don't think people sign up for that job wanting to go to criminal trials and have to testify. But yeah.
Well, wait a minute, following up on that, first of all, understand, I don't know anything about Title IX.
Yeah. It used to be probably equal funding for sports.
But I think sexual assault is still a crime.
Yes.
If someone is charged, let's say, with sexual assault by the county attorney, does that process go along simultaneously with the Title IX?
It can, or it doesn't have to. So there's no statute of limitations on sex assault unless it's misdemeanor, and the victim's an adult. So, I mean, a Title IX case could be open and shut, and a criminal investigation gets launched 6 months later, and the case doesn't go to trial for a couple of years. So they could be completely parallel at the same time. They could do one after another. Usually Title IX is moving much quicker than the criminal.
So if a person is charged with sexual assault as a crime, and you've also got this Title IX investigation, am I saying that right?
Yeah.
And the Title IX investigation finds there's no basis for it, they close the file. Can that be offered into evidence in the defense of the criminal case?
No, that would be an opinion on the ultimate issue, and it's a different burden and a different, I mean, that invades the province of the jury. Now, so that finding wouldn't be admissible, but statements that were made that were inconsistent, impeachment, things like that could absolutely, I mean, large parts of the investigation can come in, not the ultimate conclusion.
The accused could, if they're going to testify, say, well, I had to go through all this with Title IX.
I'm sure you could backdoor it and be like, well, my school investigated me, and yes, I'm still a student there, but there's probably ways to try and get it in, but I don't think you could ever get in the actual finding. So, yeah.
Well, and also you could be charged with a crime and there's no Title IX. I mean, it still would require, even if it was the same victim, if it was the victim in the current or pending criminal case, if he or she didn't go file something with the Title IX office, the university's not going to do anything.
Yeah.
Typically, it does happen, though, where both are going on.
You mean
Any other Title IX questions? We could do like a whole thing on Title IX. It's so prevalent. I mean, it's like we have middle school. I have had at least half a dozen middle school Title IX I mean, it's rampant, but
Yeah.
so this slide I just put up there, and there is obviously a therapist-client or therapist-patient privilege in Nebraska, but that's only as strong as the therapist valuing it. I mean, certainly there's exceptions. Therapists are mandatory reporters, so if something has to do with child abuse or something like that, they have to disclose it. But a lot of times we have clients who are facing a serious criminal allegation, and it's really hard on them. It's impacting their lives. They're having a lot of stress, anxiety, and they want to go to a therapist. Our typical advice is that's fine, go to a therapist. Your therapist does not need to know the details of the allegation or what you did and didn't do to treat you. Your therapist needs to know, I've been accused of a crime I didn't commit, if you want to say that, and this is how it's impacting my day-to-day life. And that therapist should be able to address whatever it may be, depression, anxiety, PTSD, without needing to know the substance of the allegations or anything like that. So we usually caution our clients, go to therapy, do what you need to do for your mental health, but under no circumstances should you talk about the substance. Anything else on this slide?
No, the only exception to that would be if you're getting an evaluation as part of like leading up to sentencing. If you're at the tail end of the criminal case and maybe it's court ordered, maybe it's something we've done along the way to position you better before the court for sentencing. Their, transparency and maybe talking more about the case is going to be to your benefit, but that's depends on the situation and the case.
And we've had cases where in pursuing like a certain plea resolution, we provide an evaluation or a therapy letter, and we put together these very detailed agreements that we require the prosecutor to sign, that they will not utilize that evaluation as evidence against our client, any statements in there for any purpose, like not even like you do not get to use this other than to decide if you're willing to extend this plea offer. So we're really careful about that plea as well. This comes up a lot in cases where maybe there's like an abuse allegation. So if something is reported to Department of Health and Human Services, Child Protective Services, they have an obligation pretty quickly to go in and do their investigation. And again, like Title IX, this is completely separate and apart from law enforcement. But a lot of times we end up seeing these intake neglect forms in criminal cases. So they have to interview the parents or okay, what are the rules of the home? What's bedtime? What happens if someone gets in trouble? So we let our clients sit down in those, but we have to be there. And we let them answer those basic, at this point, we kind of know what the laundry list of questions are. Like, how were you raised? Were you ever, we let them answer a lot of these basic questions. But we have them say at the advice of counsel, I'm not answering about the offense or the alleged conduct, so that they can check off a bunch of their questions in terms of home safety. They'll go do a walkthrough of the home, things like that. But there's nothing to say that there's no like privilege with respect to what you tell a DHHS IA worker. So, yeah. Okay, we have this going on right now pretty significantly, actually. You want to talk a little bit about this in our...
Well, as you can imagine, sometimes in addition to a pending criminal case, there's a civil case, let's say theft, for instance. Sometimes we're successful in making the argument if there's a criminal investigation going on, say this is a bad business deal. This is a contract dispute. This is no crime was committed. Somebody though needs to do some serious accounting. You guys need to get into this contract, but no crime was committed. Well, but let's say they end up getting charged with theft, for instance. And then what the alleged victim is in the criminal case has also then filed a civil suit against now the defendant in the criminal case. And that case is moving, and they're in the discovery phase, and they're kicking out interrogatories or requests for production of documents. That can get a little stressful because depending on where the criminal case is, what phase it's at, one, certainly we're not just going to go answer all those interrogatories, but not just that's going to be us communicating with whoever the civil attorneys are that are defending the suit, and having a good relationship there is really important in figuring out, is there anything that we can respond to collectively, or is it just we're going to have to invoke a Fifth Amendment and privilege because it's incriminating? There are times where on the civil case, they can try to get a protective order or stay the case or something because there's this criminal case going. The case Mallory is referring to that we have right now, the district court judge there said no, the discovery request can proceed, but so now we're surgically going through them. Request for production of documents is even more delicate. Generally speaking, I mean, those aren't going to be given, turning over documents, even if it's an individual, they're not going to be as protected, especially if they don't really relate to the case. And unless the act of producing the documents themselves would be the incriminating act, or that's going to be some part of crime, or it's going to completely, like when you turn that over, show what the mental state was of that criminal defendant, if it's like a specific intent crime. Other than that, a lot of that stuff's going to have to be turned over. But that doesn't mean the civil attorneys still can't try to object or try to, fight it off as best they can. If the other side then files some sort of motion to compel and they got to go before the district court and hash it out request by request, they can do that. But it's always kind of a balancing game because, one, you don't want to make it any worse for the client on the civil side because there can be a negative inference if they're not complying with the civil discovery request or they're asserting the Fifth and they're not responding. But at the same time, I mean, if you did turn that stuff over because you were fearful of what would happen in the civil case, is it going to come back around to the county attorney? And it's just balancing that out can get really, really difficult. And a lot of that can come down to, what the client's risk tolerance is and what their exposure is on both ends. Maybe the civil case, who cares about it because it's not going to matter if they're going to be in prison for an extended period of time. Or maybe we have to defend that, the criminal exposure's minimal, and even if that didn't go the way we wanted it to, you still are going to have your assets on the back end on the civil side. So it requires, yeah, Dave.
How often is it not stayed? Because I feel like that'd be standard, right? That's the case that's all side the same facts would stay.
Well, I mean, the short answer to that question is I don't know. Like, I don't know what this, overall, like what the statistic is and, the success rate in getting it stayed. I think it's going to be very dependent upon the subject matter that they're after, what the nature of the civil dispute is, and then how much of that, the discovery information that the plaintiff wants in the civil case, does the court feel like really relates to the pending criminal case? Is it between businesses, but there's in organizations and corporations, or is it really just between individuals? Because certainly if the more businesses and organizations there are, the less protections they're going to have compared to the individual.
How did we get? I had a situation recently with embezzlement or management, one separate company, they cross endorsing checks, just all pretty obvious stuff. And we were suing them civilly. First we tried to join Huck, or Turbig, Bass, But I thought early on we would have gotten the Ockerworth more interested. Yeah. They should be. I mean, it was like they thought it was a civil action. Very busily handing a powerful ink tray. This check is for this service. They endorsed it, put it to this account they set up that didn't have any business. It was sort of like, I thought it was like neon lights pointed at fraud. Nothing happened.
Well, one, I guess I don't want to give an answer that says what should law enforcement be doing here to.
I guess, yeah. How can we be creative and get them into those situations like that?
Well, I think it's the same way that on the defense side, we try to get creative if we know it's coming down the pipe and saying, hey, here's a little work we did. I've done it before. Like, we got our own accountant and just, we got enough information that we knew kind of what we needed to be auditing and looking into and putting our own work together. And that's risky. Like going and saying, here's our math of everything. But, it was a calculated risk. And like in that situation, it paid off. And the investigator was like, yeah, if I hadn't got that totally, because again, to get charged with the crime is just probable cause. It's a low burden compared to finding you guilty. But not to keep harping back on the same case, but the one we're referring to where this issue is going on, there, the plaintiff in the civil case, I was just in court recently and the county attorney's like, yeah, that they just showed up from Iowa with like a banker's box of records, and we're like, here you go. We think this guy stole all this. And within like a day or two, the sheriff department was like, okay, yeah, good enough for us. And they wouldn't pick them up. So some of it could depend on the law enforcement agency, how sophisticated they or their investigators are.
How busy they are.
How busy they, I mean, this is a more rural county we're talking about, and it involves, more agricultural resources that everybody's a little more sensitive about. In a bigger jurisdiction like Douglas County or Lancaster or Sarpy, I suspect, one, it's not that they won't be interested, but they're going to have to devote a lot of manpower and time. And
Is it a lot different timeline too, like you said? Is that the
well, there could still be a statute of limitations on it, but, they're just going to have to see something that gets them interested. And it might just not be numbers. It might just be how it comes about. If it's, the more it looks and smells and acts like a business dealing, that's easy for them to just kind of like shy away. I mean, that's different than like a real life victim that's crying and there's blood. And, it's their natural tendency to not want to go. But and again, in the bigger jurisdictions, they do have more sophisticated investigators that do the white crime stuff, for sure. But those guys are so like backlogged. It just takes them a long time to like put the brain power behind those sorts of cases and string everything together. And a lot of times too, they really want to talk to the other side, like the accused. And if they can't get to them, it is even that much harder for them, because otherwise they don't even really know what they're looking at. And they're not going to go and generally employ their own experts.
I've seen state patrol get involved in these like more sometimes than local law enforcement agencies too.
Yeah, because state patrol will then use
They've got some like a forensic accounting department, basically, and like the state auditor. They've got
Yeah, in this case, ironically, the state auditor did write about,
You could go to the AU.
but not the criminal yet.
Yeah.
So
Yeah. It's I'm not sure. There's not a lot of like rhyme or reason. I had a case with like a catering company, and we're talking like $8,000 in tips. But the catering company happened to be friends with a former FBI agent who like went in undercover and did this whole like sting, and like then they prosecuted them. And once you get over 5,000, which I think this needs to change with inflation, but it becomes a 2A felony, which is 0 to 20 years. So if you do something above $5,000, like you're facing 20 years, and then client ended up getting probation and a misdemeanor, and it was not a huge deal. But like why did they think that was worth their resources? I don't know.
it makes it hard for you guys to negotiate, but what do you?
Well, what I would say about theft cases, I mean, just I guess because theft cases do relate a lot to civil matters, ability to pay restitution or pay back what you stole goes a long ways with everybody.
In terms of avoiding jail.
Yeah. If you're just stealing stuff and you have no way to return it or repay it back, you got a problem. But money does talk kind of across the board, so.
All right. I want to file a civil complaint or protection order. I mean, we usually do not want clients doing this because that isn't necessarily going to require them to be doing things under oath. So the answer to that is usually like a hard no. The point is talk to a lawyer, nobody else. If your client ever calls you from jail, these calls are always recorded. So just hang up on it. Tell them this is recorded. We're not talking about. I mean, I don't like to talk to clients about anything, even if it's like this is a recorded lie. I trust nothing. I just don't trust those calls. The dirty call, not that non-criminal attorneys are really going to do that, but the dirty call is when like a named victim or witness, somebody calls the accused and tries to get them to make admissions, and law enforcement is right there recording. So yeah, you just never know who's on the other end of a call. Save everything, preserve evidence. I mean, that's one thing to tell them out of the gate is if you have anything, a text message, a voicemail, anything you could screenshot that might be helpful, just like save it and ask an attorney what to do with it. This is kind of separate, but we have a lot of people who hire us before they've been charged with a crime. And the strategy becomes, okay, well, do we want to turn this over? Because we, as defense attorneys, we only have to turn over evidence we intend to produce at trial, which means impeachment evidence. We don't have to turn it, if I've got a text message, I don't have to turn that over because I just need to go ask them on the stand. And if they admit it, I don't need to use the text message, right? I'm only going to use it to impeach them. So it's like, do you want to turn that over to law enforcement and give them the opportunity to explain it away? Usually we're telling clients, unless this is like borderline dispositive of whatever the issue is, we're usually going to save it, but still save everything, obviously. Another thing that we do when we're representing people before they've been charged is we send law enforcement notice of representation, but also evidence preservation, and we tell them to go look for things. We have a case right now in Lincoln where I have said, you should go ask the accuser these 5 questions, because if she answers honestly, I think you will find there's no probable cause. If my client gets charged and they didn't do that, or they didn't go look for that evidence, that's an exhibit for us. Hey, we told you to do this, a bias investigation, because we told you to go do these things that could show the whole story, and you elected not to do that, and then you charged my client. So here's how we're here, ladies and gentlemen of the jury, because law enforcement ignored our request to go look for exonerating evidence. Or maybe they go do it on occasion, and your client avoids a charge. But this is something that we like to do in a lot of our cases where our client hasn't been charged yet. So this is more like federal. We're getting into kind of like federal land here. But sorry, go ahead. Back.
No, I'm gonna
Forward?
Yeah.
Oh,
So I know we're a little short on time, but I think what I want to talk about might resonate. The slide that Mallory showed earlier, where it says for the jail calls, somebody's calling from jail, we don't want to talk to them. I think where you all, regardless of your practice area, let's say you have a client or you know somebody's family and they call you and say, hey, little Johnny got arrested and he's in jail and he needs to bond out. We've never been in this position. Nobody knows what to do, but you're the first lawyer that is in their phone that they know to call. That's going to be somewhat one exception to talking to people when they're calling from jail. Even though those calls are recorded, one, they have to call somebody to let them know I've been picked up. But once that happens, then the process needs to start being, well, one, where are they? What are they picked up on? And what maybe is their bond going to be? And so I'm going to jump kind of to that part of this, because maybe a lot of you have run into this or you've heard about it where you have a client or they have a family member, they've been taken into custody, and now everybody's like, what do we do? How do we get them bonded out? Nobody's been through this experience before. So the way it generally works in Nebraska, and if it's a state crime, okay, well, not federal stuff, they've been charged or they've been at least picked up for an allegation of violating state law, they're going to be taken into custody. That could, if it's a low-level misdemeanor, they're probably just going to be cited and released. But if it's like a class 1 misdemeanor or it's certainly any felony and there's probable cause, they're going to be taken into custody. The more rural jurisdictions that don't have court every day or even every week, they might just have a bond schedule. You show up to jail and they're like, okay, you got brought in here on possession of controlled substance, class 4 felony. If you pay $10,000, 10%, which is $1,000, you can go home right now. You're not going to get in front of a judge. They're not going to tell you what the possible penalties are. That's one way. And if they call, and whether they have access to the money or they call their family and their family shows up and pays it in cash, they can get out. You get in Douglas County, you get in Lancaster, you get in Sarpy, you get closer to the eastern part of the state. Once you're taken into custody, there's not going to be a bond schedule. You're going to have to appear before a county court judge, even if it's a felony, because all felonies start out in county court, and they're going to tell you what you're charged with, what the possible penalties are, and they're going to want to figure out if you have an attorney, if you're going to hire one, and then they're going to set your bond. If they set your bond, let's say it's $10,000, 10%, so you're going to have to post, again, $1,000, that's going to have to be by cash. And cash bonds can be paid there at the jail, wherever that custody or detention center is, or usually to the clerk of the county court for that respective county during business hours. But this is where it gets a little nuanced, where the client wants to call and say, I gotta get bonded out of here. This is all BS. I didn't do any of it. The brakes got to be put on that right away. You know, where are you? What were you booked on? Thanks. Do you know what your bond is? Because if it's more rural county, they will know, but you're not going to be able to get that information from anybody. And then if they're talking to their family member who reaches out to you all, it might be a matter of, what do we got to do to get the financial resources in place? Sometimes if it's a really big bond, let's say it's a $500,000 percentage bond and they're going to come up with $50,000 if they want to get their loved one out, that might require moving some things around. And I know that I've had clients where their family has talked to, their civil attorney or their family attorney to figure out how can we do that. Or sometimes they figure that out on their own, or they refinance their house, or they take out a personal loan. I mean, it can get sad real quick in terms of like the desperate measures people go to take to get money to pay to get their loved ones out. Because the other part of that is, even if you have a high bond that needs to be posted, but you still want to get a defense attorney, not just us, anybody, you're kind of in this predicament of, I got to pay the bond, I got to pay a retainer. How do I make all that happen? And again, that's where I've seen individuals speak to other civil attorneys that they might be friends with or that they've used in the past to kind of try to work through some of that stuff, depending on where they're at in life. Federal court is different, though. They get picked up in federal court, yeah, they might call and tell you, I got picked up by the feds, and maybe the feds are holding them in a county facility, but they're not going to bond out with like a cash bond. They're going to have to go before the magistrate, of whether it's up in Omaha or Lincoln, and they're going to have a detention hearing where they're going to figure out, is detention while we're awaiting trial appropriate? And for some crimes, detention is considered proper. There's a presumption that it is. Let's say it's child porn, for instance. Okay, well, the presumption is you're going to be held until this case is resolved, unless you, defendant, can rebut that presumption, and you and your attorneys can make me feel better about why you should be out awaiting trial. Or if it's a crime where there's not a presumption and the court feels it's appropriate, they'll put you out on pretrial release. That might entail a number of conditions like an ankle GPS monitor. You have to go live with a third-party custodian.
That's important, and why it's helpful for us to know like as soon as possible if we're going to be helping someone in this type of a case. A lot of times we will call a third-party custodian. Federal happens really quick. I mean, sometimes we get a call and it's like the next day we're going into court. But third-party custodians a lot of times need to come to court and get on the stand for a few minutes and just say, this is who I am, this is where I live, I agree to be a third-party custodian. They don't have to like agree to watch that person 24/7. But like in a child porn case, I mean, they can't have access to certain electronics, so that person has to maybe sometimes even say, we'll put passcodes on these things. These are the devices in my home. So for us, getting a third-party custodian lined up can be really helpful if we're going to try it. If we're having to go rebut the presumption of detention in federal court.
And sometimes if you get that call, or the family member got the call and then they're contacting you all because you're the lawyer that they know, the individual that was picked up or taken into custody, they might not even really be too sure. Is this a state case? Is this a federal case? But once the call comes in, all the more reason to like get in touch with a defense attorney like right away, so then we can try to figure out, what are we dealing with here? Is it a state case? Is it a federal case? And oh, by the way, there are state cases that then turn federal where I've had it and it's terrible. It's like the worst series of events where they get picked up on state charges, they bond out, they go through that whole process. We think, okay, this is what we're dealing with. And then, oh, by the way, they go get picked up by the feds. The state dismisses the state case because they got indicted, and now we got to go do a detention hearing and kind of like relive that nightmare for a second time. So it can get dicey really quick, but the point is, if anybody reaches out and they're like, hey, so-and-so's been taken into custody, we don't know what to do. They're saying that there's maybe this bond amount, or they got court tomorrow at 2:00. Get in touch with, a defense attorney that can like call that county, can kind of figure out, what are they being held for? Is there a probable cause affidavit out there that's not on justice, but we can, have it sent to us? Maybe we can reach out to the prosecutor. Hey, we know we set for court tomorrow. Do you have any idea maybe what you're going to ask for bond? That's really important, because then if we can give somebody 24 hours notice even of the finances they need to get in order so they can get that money on hand to pay it at the bond hearing, that can be a big time saver. So I know it's kind of like a real down and dirty on that aspect of it, but I do feel like it happens a lot where civil attorneys are the first kind of line in the sand when they get contacted by a client or former client about a loved one or somebody they know who's been taken into custody, and you just happen to be the first lawyer, so they're trying to figure out what they should do.
What different? Well, I don't know.
We're not licensed in Iowa. We have some attorneys that are licensed in Iowa in our office, but the two of us are not.
Well, for the federal side, I don't really know. For state, yeah.